All right. Good afternoon and welcome everyone. Welcome to our informational session today on the Central Guide, our court's all-new digital tool that is designed to replace the current court manual. This session is being recorded and will be posted on the court's website for your convenience. My name is Jan Zari, and I'm a management analyst here at the Bankruptcy Court, and I'm based in Los Angeles. I'm joined here today by Jeff Kozad, career law clerk to Judge Zerzullo, who will be facilitating our session today. Mark Francisco, management analyst, has also been instrumental in the development of the Central Guide and is also here to help answer any questions you might have. You may contact the court via email, telephone, and our live chat feature, and all of this information is available on our court website. And with that, I'll turn it over to Jeff.
Well, thank you very much, Jan and Mark, and thank you to anyone who's watching this today. We're very excited to have released the Central Guide last December. And as Jan mentioned, the Central Guide is designed to replace the court manual. And what you see on your screen right now is the homepage of the court's website. And the Central Guide lives right here under Rules and Procedures, where we have the Central Guide and the court manual. Let me just start out with the court manual, because the court manual is a 200-page PDF with 6 sections and about a dozen appendices. It was first posted on the website 13 years ago in 2009, and it's been a workhorse. It started out as 100 pages and has doubled in size over the years with all kinds of important information, but it's become something that needs a bit of a makeover because it is so large, and we now have the digital tools available so that the vast majority of information in the court manual is already somewhere else on the website. So 3 years ago, we started a project under the supervision of the court, our court's case management committee, to take the material from the court manual and convert it into what is now the Central Guide. So far, we've had about 200 attendees at our informational sessions on the court, the Central Guide, and it's became so popular that we decided to do this recording, put it on our YouTube channel for you all to take a look at your convenience. Now, there's 5 things we're going to do today. We're going to identify what the Central Guide is and what it is not. We're going to show how the Central Guide is organized, the format of each of the sections in the Central Guide, popular topics in the Central Guide, obscure yet very important and detailed topics in the Central Guide, and then we'll have a bit of a wrap up. And we'll stop at periodic points for questions that are being submitted or have been submitted in our chat feature. So you want to start out. The Central Guide has 4 sections, and right here, the first one is 1-00, Introduction to the Central Guide. And here what we do is we explain a little bit of the history and some short information on the 4 sections in the Central Guide to show you what you can expect. And then we also have a public notice, which we'll look at, which compares information that used to be in the court manual and where you can find it in the Central Guide. So the Central Guide is divided into 4 sections, and it was primarily organized and thought of to start with section 4, which is for the first time you can find any local rule and click on it and see if it has a form associated with it. Instead of looking in the long listing of forms, you can simply click on something here. It'll have a blurb on it, and then there are the various forms and other websites that you might need that match the local rule. Now, as you can see, section 4 is really long. It has well over 100 different entries. And so we didn't want to put this one at the very beginning. Instead, we put it at the end, but we repeated most of this information in section 1, 2, and 3, because these are the ways people are used to thinking of these topics rather than having to look in a rigid sequence in which we find the local rules. So section 1 is common bankruptcy procedures and information. And section 2 is serving documents and giving notice. That's a brand new way to look at these items. We did a survey district-wide of the court and of the public, and we found that the public was very interested in having a section on serving documents and giving notice. Then we had a section on how to search a judge's web pages. There's a lot of important information on here, and you can find out different practices of the judge who's presiding over your case right here. Now, what is the central guide is a fantastic starting point for something. I mean, let's say you want to learn about how to apply to have a hearing set on short notice. And so we have some information here, a few steps, and the applicable forms. But this is not a practice guide. We don't cite any case law authority to the Bankruptcy Appellate Panel, the Ninth Circuit, or the Supreme Court. And we don't include every step that you need to follow. So it's not a full, complete practice guide, but it is an excellent starting place for information. It is also not a substitute for hiring an attorney for things that you don't understand, or if you're having trouble completing things on a timely basis. But it is a starting point to offer explanatory information. And most importantly, if you need things in a local rule and you want to find a form related to it, let's say you're in a chapter 13 and you need to know what form you have to file about tax returns. Well, there it is right there at your fingertips. Right there. There's the form, and you could download that and file it. Now, how is the central guide organized? If you go back to the main page, we have 4 sections: common bankruptcy procedures and information, serving documents and giving notice, judges procedures, judges web pages, and match a local rule with forms. And each of these particular large sections has smaller sections. There are 21 here. There's an introduction plus 21 more in the first, an introduction plus 21 more in the second, an introduction to 13 more in the third, and in the local rule section, they're listed by local rule. So this one here is literally local rule 1002-1A2. And if it pertains to mailing address, and so it has a little bit about that. And then here is the change of address form that you need to use. Within each section, we try to group things by topic and then also alphabetically. So here we are. In the introduction, we've got the court divisions. Then we have a lot of stuff about filing. And within the filing, we have some more specifics. And then after that, we go alphabetically to H for hearings, and then M for mediation, all the way down to V for viewing. The same thing with serving documents and giving notice. We group them by addresses you might need to serve somebody. Hearings, notices, orders, all the way down to subpoenas and summons. And the same thing within the judges, the information about a chambers, evidence, hearings, special tabs, and variants. And we wanted to do this so it was easy for your eyes to find things, and also so these will be consistent. We want the local rules sometimes change. Sometimes the rule is deleted, sometimes one is added. We can't do anything about that. But rules are all in sequence. So if you add or delete a section, it doesn't do anything to the table to the sequence here. But things could get upset in these other ones if we hadn't thought ahead. So we had many sessions with court staff and with attorneys and the public, trustees, etc., bankruptcy, appellate panel, Ninth Circuit, district court, to come up with all of these topics so we would be as thoroughly as possible. Because this is how the court staff's going to communicate with you for a while now, in notice to filers that are put on dockets, and when we've more order gets marked unused, or in a tentative ruling, we want to use these section numbers, and we wanted them to be reliable for a long time. Now, where can you find things in these? In section 1, we have in section 1-00, we posted a public notice, which is on the website. And in that public notice, at the bottom is a chart of location of information in the court manual versus location of information in the central guide. So those of you who are used to using the court manual, you can find out where the item is first in the central guide. So general information is throughout section 1. A lot of filing information, filing your bankruptcy case, filing claims, motions. Here are the sections where you can first find them. The CME-CF procedures are in a few places. The lieu procedures are in a few places. And then here are your favorite appendices. If you just need a phone directory, you go to section 102 or 10711. The same thing if you need information, you need an address for a federal or state government agency, go to 2-03. And then here's your judge's copy link. You're contacting emergency motion contacts for judges staff when you want to see if an emergency motion can get put on calendar. When you have to give 3 more days to act or respond, it's all right here. And this is printable. So you can click on the public notice, and here is the 2-page printable, so you can have that at your fingertips. So we want you to be comfortable knowing we didn't just wipe out the court manual. That information was very important, and it's just in a new format in the central guide, making it findable in a different way. Now, many of you are used to searching using the Control F feature, which you can do in the central guide. You just click on Control F, and let's put in signatures. And what happens is in the table of contents, signatures will appear every place it does. So here's several of them right there: signature, signature, signature requirements. So when you use the Control F feature, maybe you want to look up fees, and fees are in many places. The Control F feature gets you to the table of contents. We do have another way to search for things, and that's this dedicated search bar right here. So if we put in fees in the search bar, it doesn't highlight the table of contents, but it lists the sections that you can find information about fees, and then you can click on one. Oh, here's one on fees and an appeal. So you click on that, and it goes to our filing fee chart, which is already on the website. We didn't recreate it. It's already there, but this is just one way to search to find it. So we don't force you to go to one place about fees. Right now you have to. You'd have to go to the court manual, into the filing fee chart. Here's another one under filing fees. Maybe that's where you're looking. And it gives you the same fee chart right here on the website. So those are 2 ways to do a search. Finally, I want to point out that we have a lot of related headings. So here we have headings of filing, and we decided to put that in capitals so your eyes could read it. And then within that, there are a lot of subtopics: signature requirements, fees, filing something electronically, claims. Go down here, the same thing. There are a lot of things on addresses and hearings, notices. The same thing here, especially in the court, in the rules. If it's dismissal, we put those headings, or conversion, or down here on notices, or chapter 11. So we really try to identify groups of headings so it was easier to find things. These might not be the same titles you would see in the local rule, but on the central guide, we had the ability to use flexibility to have headings that they're grouped, and then we'll have the specific topic listed after that. Jan, this is a good time to stop for a couple of questions. I see that we have 1 or 2. What would you like me to answer first?
All righty, Jeff. Let's see. Question number 1. Do you need to check often to see if section numbers have changed in the central guide?
Very good question. And again, we do not need, you won't need to check often. We've worked really hard to come up with these section numbers here so that we can communicate to you through our notice to filer on the docket, when a lieu order is marked unused, or in a tentative ruling, or on the judge's website. We wanted those to be consistent, so you don't have to look every single time. The section numbers are designed to stay the same for many, many years to come.
Perfect.
Is there another one?
Yes, one more question here. Are there practice pointers and checklists of how to do things?
Oh, definitely. Yeah, by saying it's not a practice guide, we don't want you to think that there's no practice pointers. We have checklists in many of them. For example, let's see if there's something in section 1. Here's one. Here's section 1, filing bankruptcy. I'm sorry, this live chat feature is brand new and it keeps popping up. Filing bankruptcy, filing amended forms, notice of deficiency. Sometimes you're going to get a note on the docket or in the mail from the clerk indicating that you haven't filed your bankruptcy case commencement documents in time. So here's a little checklist that has the deadlines and filing amended forms. You might need to correct an omission, convert the case, and then file some new forms. You might have to file amended statement of social security to numbers. So, and then of course it has a warning up here. My apologies for this live chat pop-up. So there's an example where there's a checklist. Here's one on something that is not so well known, but sometimes you might have, let's say, 5 motels that are all run by the same company, and each motel though is its own entity, and they file separate bankruptcies. Well, it might be better to have 1 docket rather than 5 dockets. And when you do that, that's called joint administration of cases that are related. So here we have a first, second, and third procedure of what to do, tells you what forms to file, what orders to lodge, what notice you have to send. So that's an example of a couple of items that need some kind of a checklist. Here's another one. What if you need to file a document and it needs to be sealed? Perhaps it has confidential information in it. So in the court manual, there was a procedure called court permission to file under seal. So there we go. We have the steps you need to do. And then if there's a central guide supplement, phone directory for court division. This supplement actually used to be one of the appendices in the court manual. Now it's called a central guide supplement, and it has the rule number, the local rule number that it's related to. And then there's, you might have to serve a judge's copy. This used to be Appendix F of the court manual. Now it's associated with the local rule. And then finally, here's another one that you might do that is pretty popular. Sometimes you need a hearing, but 21 days is too long to wait for a good reason. And so we have a procedure on asking the judge for permission to have your motion heard on fewer than 21 days. So we have the procedure of what to do, and then the various forms you need to file. Now, if this was a practice guide, it would explain all the things that would happen, any opinions from higher courts, appellate courts, and what to do if your motion is denied. But this still doesn't mean it's not a good place that has a good starting checklist. It gets you to a place where at least your request that you want the judge to review is going to get there in a timely fashion, and it won't be delayed or denied because you forgot something basic. Are there any other questions, Jan, right now?
We're good, Jeff.
Okay, very good. Well, next, let's take a look at the format of each section and what you should look for. What you should look for in each section. So let me give you some examples. The obvious thing you might find is a section number and a title. So let's just go to transcripts and audio recordings. That's section 1-20, and then it's the 20th in the sequence. And if you notice the way this program is set up, here's the old title, transcripts and audio recordings, and here's the section number. That's just the way this program is set up, the fields. We wanted to make it very visible for the public and for the court. So we have the section number repeated here and the title repeated. So that's something you can always look for. What's the main section, and then what's the subsection within each. We also mentioned that there are going to be topics within a section. So here again, we have filing bankruptcy. Here's electronically if you're self-representative. Here's the forms you can look for. Here's filing amended forms. Here's filing a claim. So these are all filing. They're going to be organized together by related topics. For example, how about probably the most common motion filed in bankruptcy is a relief from the automatic stay. And so that's covered by Local Rule 4001-1. And so we have automatic stay provided all the way down to here, section 362. Sometimes you're asking for relief, and sometimes it's not relief. Maybe it's just to continue the stay or extend it or impose it, or it's involving deposit of rent. But nevertheless, all these are grouped by here. And so these headings are placed there. And we have little pointers too. For example, if it's involving real property like a house or a building, it often involves foreclosure. So we put foreclosure right there in the title. And often personal property, it could be equipment, but usually it's an automobile. So we try to put it right there. Unlawful detainer. Maybe somebody's gone to court and it's time for an eviction. That tends to involve an apartment. So we put that there to make things easier to file. And even here, two different parties can file a motion to continue the automatic stay or extend it or impose it. One party is the trustee and one is the debtor. And instead of saying just debtor or trustee, we indicate that a motion has to be filed. So we really worked on the titles to make things findable. Now, another thing you'll find in any one of these sections, we can just click on one, are there rules that apply? So here we go. On all these sections down below for local rules, we identify from whence it came. So here's local rule. The section is in 290-1. So we include all of the 2000 series local rules. And we aren't able to pull one out each individually, but they're easy to scroll through once you get the section. So this is just a section on the 2000 series and it goes to the end. You can scroll through and find that. You also might find that there is another website you need to find. So here, there's an annual renewal fee to practice, for attorneys to practice in our district. And so we click right there and we send you out to the district court website and to their notices about applying to be admitted to practice in the central district, and then the annual renewal fee. Something else that you can find in addition to the local rules is our federal rules of bankruptcy procedure. And these all involve due process. So in section 2-00, we have a list here, the bankruptcy code and the federal rules of bankruptcy procedure, federal rules. And these are also in a lot of different sections. Let's click on one here. For example, enforcement of judgments. Let's click on one of these. And there's the federal rule of bankruptcy procedure that applies in addition to the local rule. Sometimes there are forms that the Administrative Office of U.S. Courts publishes to apply in every bankruptcy case. So for example, right here, we have our first forms page, and it identifies forms that match local rules and forms that are published by the Administrative Office of U.S. Courts. You can always look, hey, is this a local form or is it a national form? And then sometimes it's a form that we have that's not identified with a particular local rule right now. Maybe in the future, but for now it's not. So for example, in your adversary proceedings, perhaps you need an abstract of judgment or a writ of execution, and our court provides these on our other forms page. So you see at the bottom, it doesn't have a form number. It's just your abstract of judgment. We used an example of the district court. There are many pages that use websites from our related agencies. For example, the United States Trustee is the main regulatory agency, and it supervises the issuance of bonds and also other trustees. So here is a site where we provide the U.S. trustee manuals to banking and bonding, a trust chapter 7 handbook, a chapter 11 handbook, a subchapter 5 handbook, chapter 12, and chapter 13. In addition, for meetings of creditors, you might need to contact the U.S. trustee, and here we go. Section 2-04 has information about that, and it has the Region 16 website right here. The United States Trustee is divided up into regions across the country, and the Central District, all of our divisions and counties fall under Region 16, and this is their website, and you can find a lot of information. There's another place that you might have to look if you're ordering a transcript of a 341A meeting of creditors. You need to contact the U.S. Trustee's office to find out if they have audio recordings or written transcripts. And so we provide the links to those websites. In addition, we have links to the district court. We showed you one of those. We also have links to our appellate courts. So down here in the 8000 series, here is the bankruptcy appellate panel. And there is a link to the Ninth Circuit BAP and to their litigants manual right here. In addition, an appeal may make its way to the Ninth Circuit, or you might file a motion to have your appeal go directly to the Ninth Circuit instead of being heard by the BAP or district court. And so we have a section on that. And the website to the Ninth Circuit is right here. Finally, the text, there's lots of things you can find in a text, and this is a perfect example. Look at all these citations to Title 28, giving you the right for an appeal, to the FRVP, Federal Rules of Bankruptcy Procedure, for how your appeal process complies with the FRVP, to official forms, and to the Federal Rules of Appellate Procedure. So there are, in every single one of these, there will be a citation to the applicable rules. Something else you can find is pointers. Well, this thing here, filing a directed appeal, is a perfect example. Look at all these pointers. There's a whole page of them because this one is very complicated. And here is another one. Let's look at warnings. How about judge's copies right here? So this tells you to serve a judge's copy and why you need to get it in front of the judge. Here's one here on filing forms. So again, there's citations, read these forms carefully. There's a filing fee. So you might find little warnings to help. And if we provide some kind of a form or important link, look for see link belows. See link belows right there. Sometimes the court does not have a form. And we also try to tell you that. So here's an example of filing a motion to withdraw the reference. And let's go right here. And so we say a motion must be filed. Okay, this one doesn't have it. We probably should say the court does not provide a motion. Here's an example here under related cases, joint administration. We say, first, you have to file a form. The court does not have a form motion, but we do have a form notice. And so we point that out, give you the citation and say the link below. So that's kind of a survey of things you can find inside these sections, the thing you should look for. Okay, Jan, I see we have a couple of more questions.
Yes, we do, Jeff. The first one, are complete lists of LBR forms and all the LBR still available?
Yes, they absolutely are. And a one-stop place to look for a complete list is right here in section 2 for serving documents and giving notice. All that's involved with due process. And if you click on the first one, 2-00, right here is the best place. There is a complete bankruptcy code. Click on that, it goes to the outside. We don't host one ourselves, but there's the bankruptcy code, US bankruptcy code. It's 2020, it's not quite updated, but it's very difficult for any website to maintain a perfectly current US bankruptcy code. Here's all the sections there. In addition, the Federal Rules of Bankruptcy Procedure, go out to a website, Federal Rules of Bankruptcy Procedure.org, and it's got all the individual rules and you can look them up by section. We have the same thing for the Federal Rules of Civil Procedure. Here is, I believe this was more closely related to the question, is there a complete set of the local rules? Yes, right here is from January 2022. Here is the complete set of local rules. I'll also show you where those are on the website. And finally, we do have the web pages of all judges are right here. So those are all the rules where you'll find procedures to follow. In addition to that, we have 2 places where you can find the forms. First one is right up here for filing forms. We have use after a bankruptcy petition is filed, and this is the local bankruptcy form list you're used to. So they're all here. There's a huge, we have a lot of them. Our court is so large and we have so many parties that are self-represented that for years the court has had a policy of trying to make it as simple as possible for practicing in our very large district and for self-represented parties to have some consistency of what kind of forms they can use and what kind of forms they might receive. So here's the long list of forms that you're used to. And under rules and procedures, the local bankruptcy rules are right here. And under forms, here are local rule forms, in addition to mediation and petition forms and other ones. So yes, the complete lists are still on the website. They're not going anywhere. The central guide is a different way to just point you to the website. Okay, thank you. Is there another question?
Yes, one more question here. Are there instructions for when I need to give a party 3 more days to file a document?
There certainly are. Now, most of the time when you, most of the notices that you file go with a motion that say there's a motion to, let's say, sell a property, and you set a hearing on that motion. Okay, well, when there's a specific hearing date, your notice may provide a deadline, and the deadline's tied to that hearing date. So you'll say 14 days before the hearing or 7 days. But for a lot of motions, there is no hearing date. There's just an opportunity to request a hearing, or perhaps you filed a notice of a discovery request. And in that situation, our federal rule 9006 requires that if you mail this to a party or do other specific kinds of noticing, you have to give a party 3 additional days to respond. So if they have 14 days, it's really 17. If they have 20 days, now it's 23. So there are a few places you can look for that. Under serving documents and giving notice, right here, 2-08 is there'll be a hearing only if a party requests, and that goes down to local rule 9013-10. And when you click on that, it explains providing of notice, it explains the 3 additional day procedure, and it explains what to do, the kind of situations it applies in and what to do. If a party asks for a hearing, you got to set it for a hearing. If they don't, what you can do. And so here are the forms we have, and there is a supplement that came from the court manual. It was Appendix I. Now it's a supplement to FRBP 9006F. When a notice must indicate a party has 3 additional days to respond. It explains the procedure, the situations in which it applies or does not apply, and then it gives sample language, what to put in your notice. Here's the language right here, right there, what you need to say. Now, if you like copying from a form, we have a beautiful court form that has the language in there. It's called Notice of Opportunity to Request a Hearing. And in that notice, it says deadline for filing and serving opposition papers. And there's the language right here that you need to put in a notice, because some people will want to create their own notice without using this form, and that's fine. This is an optional form, but here's the language that you have to use. This item is so popular in the terms of how often it's used that this information is repeated in a number of places for where it's used. So for example, let's say you are in a Chapter 13 case. There are numerous motions and requests for relief that can be filed without having to set a hearing unless somebody asks for one. So down here in 3015W, opportunity to request a hearing. So if you're a Chapter 13 practitioner and that's where you'd look, here is the same information. Notice it's identical to the previous one. In addition, this works when there's a request for a discovery made under 7026.3. Let's take a look at that. Where is it? Right here. Interrogatories and requests for admission. So we cite the rules and we say a party has 3 more days to act or respond when these types of discovery, and there the supplement is again. So it's also repeated in, we have a wonderful, this is actually duplicated, but we have a wonderful place where you can read all about general due process, motions, 6 types of due process and notice. And we list the 6 types here. And one is there may be a hearing if a party requests. We have the supplement again here and the notice. And then finally, this information is also here in 9013.10. And 9013.10 is the local rule that gives the authority to use this procedure, and it's very detailed what to do. Okay, thanks for that question. Is there another one, or are we ready to move on?
No other questions for this section, so we're ready to move on. Thanks, Jeff.
Okay, thank you. The next thing we're going to look at is popular topics, meaning topics that appear often either from a practitioner's experience and viewpoint or from the court. Okay, so the first one is signatures and fees. When you attempt to file something with the court, you have to have signatures, and if there are fees apply, there must be fees. So right up here in section 1, right at the top, we highlight that signature requirements for any document and fees. And the current signature requirement is that all signatures have to be holographic. And holographic means someone has actually picked up a pen and signed the document. There are some exceptions. If you are an attorney and you file documents, you have a login and password, you can use what's called a CMECF signature, which is a slash for yourself or for your assistant who does the proof of service. And then sometimes a party, a self-represented party, gets permission gets a login and password to file their case electronically through something called ESR, or electronic self-representation. In that situation, there are pages that need electronic signatures, and the court does accept that. In addition, any party can file a proof of claim, and it's a field. So there's fields that filled in, including signatures, and an electronic signature will be accepted. But other than that, it requires holograph. But signatures are such an issue that anytime there's a signature issue, we put the links to the rules. So right here in 5005 is the general rule on signatures or on filing, which indicates that fees and signatures are required to file the document. So Rule 9011-1 governs signatures, Rule 1006 governs fees. And we have the procedures for using an electronic signature here, and we have a filing fee chart. And of course, these are going to be repeated in 1006-1 and 9011. So this is a very popular topic. You'll find it all over the central guide. The next one is just filing bankruptcy. Now, in the court manual, we had a checklist of forms that need to be filed for filing bankruptcy. And whomever does the QC on the bankruptcy case, whether it is one that's brought to the filing window, whether it's mailed in, or whether it's filed through CMECF, we use a checklist. It's 25 pages, and we do it. And so this is what we look at the court to QC your bankruptcy filing. So we thought it important to take this information from section 2 of the court manual and repeat it here. So make sure to take a look at that. You'll see it's the same. But now, instead of saying court manual, it's a central guide supplement. In addition, we have a link to all the bankruptcy forms. So here we go, right here. We have there's a filing fee chart and the petition forms. Many of you will use a software package, but if you don't, or if you need to file an individual form, here they all are. Here they all are. Here are the petition packages with all forms combined. And then here is a list of all the forms individually. Now, in terms of filing, it's not just about forms, it is also about how you file it. For attorneys, they can use CMECF. So we have a link to all of the CMECF training, e-filing manual, help desk, resources, everything you could possibly think about for filing is right here in this one-stop electronic access for attorneys. In addition, for self-represented parties, we have a page for electronic self-representation for filing the bankruptcy, and when it applies and when it does not apply, because it's only in a 7 or 13 and it's only for non-attorneys. And so we have checklists of the forms, the style guide. We've got all the information here at your fingertips. And now for self-represented parties who want to file documents in their case after the bankruptcy is opened, we also have a procedure called electronic Dropbox. We refer to it right here. This goes to a page on our website, and there is actually an application. It's not open to everybody. You have to apply to use it and to get a login and password. And then what happens is the party submits documents through this Dropbox feature. Then the court reviews them to determine A, if they should be filed, and B, then the court does the filing. So this is really a submission. It's not an actual filing, but they're submitting documents with the intention of them being filed. And so we have a web page here on our court's website, and it goes over all the procedures and the form you can fill out. We mentioned earlier that it's very common for deficiencies to exist at the beginning of a bankruptcy case. And so we have a section here on notices of deficiency with a big warning on to pay attention to your docket or your case might be dismissed, the citations, and when you might need to file an amended form and even a summary of an amended form. So all this is right here at your fingertips. Okay, another popular topic is in an adversary proceeding, you may have to file a summons. So in section 2 under service and notice, we have a page, a one-stop page on a summons for to appear in court to respond to the adversary proceeding right there, or perhaps it's an involuntary bankruptcy and the creditors have to serve a summons on the party whom they wish to be a debtor. And in the rare case that you're in a chapter 15, you need injunctive relief, you have to have a summons. We put all this down there because these are the 3 different summons that our court provides copies of for your use. We also indicate how you got to prepare it and submit it to the court for us to fill out an issue. Serving it, the timing, a summons in bankruptcy is only alive for 7 days. We cite the rule to that. And here are the ways you can serve the summons under FRCP Rule 4. And finally, and then filing a proof of service. Sometimes you need another summons. You need another summons because the first one you couldn't serve it timely, or perhaps there's a new party that has to be added. So we have a form called request for the court to issue another summons. In legal vernacular, this means an alias summons, but the word alias does not actually appear in the federal rules. So the word that is actually used is another. So that's a request the clerk issue another summons. And we even put the date out here. Original summons not served, and we indicate the 7-day rule, or perhaps you have to add or join another party. So summons are very popular. Be sure to take a look at that page. Now, the court cannot possibly identify all the rules for serving a summons. So I believe somewhere here we say, look, please read these rules carefully so that you do it properly. And if you need to hire an attorney, we recommend that you do so. Okay, moving on here, there are a number of other popular topics. And notice how we're mentioning warnings that these things are popular because mistakes are made and it may get your request denied or delay getting your request in front of the judge. And we want you to have as much information that we can provide to help you get your request in front of the judge timely and competently. Transcripts are a very popular item. And that's why we have it in section 1 at the bottom. We have a beautiful transcript page, and it's not just a transcript, which is printed, could be an audio recording. And our court's website, we have a transcript page right here. And it tells you all kinds of good information about getting one and provides the forms that you have to fill out. But we want you to know that the only transcript the court can provide are from court hearings, because a transcript and an audio recording is of oral testimony that can be provided at a court hearing, at the U.S. Trustee's office at a meeting of creditors, or in someone else's office in a deposition or Rule 2004 exam. So the court supervises the hearings, but the court does not participate in the meeting of creditors. It does not participate in the testimony that's given orally and recorded at your office or another lawyer's office. So we make clear those particular items and how you might go ahead and get copies of those. But it's popular enough, we put it right there at the top. In addition, near the very end, of our section, we talk about privacy policy and redaction. And there's a procedure that needs to be followed when a transcript is created, but before it's disseminated, parties get a chance to look at it and see if there's confidential information or personal identifiers that need to be redacted or crossed out. And so there's a procedure for doing that. It's right here. We mentioned earlier due process. There are 6 types of due process when getting your motion in front of the judge. 9013-1 is our common motion rule. And so right here at the top, we put the 6 types of due process. And I highly recommend you and your court staff take a look at this here. The common one is there's going to be a hearing. And in our court, the hearings are on between 21 or 42 days of notice. Sometimes there will be a hearing, but it can be on less than that, between 2 and 21 days. And even in rare occasions, there could be a hearing on 48 hours of notice or less. These are the local rules that apply in those situations. And sometimes there's only going to be a hearing if a party asks for one. And then we have 2 types where there is not going to be a hearing. And a few parties may have to be served by mail, or there won't be a hearing and nobody has to be served by mail. And then, but each one of these requires notice. A motion is a request for relief. The notice is a summary telling the parties a short blurb on what you're asking for, and then what they can do about it. What is their deadline to respond, and what happens if they don't respond? So we have a hearing notice right here, notice of opportunity to request a hearing, and then a notice of motion for order when there isn't going to be a hearing, and the situations where a party has 3 additional days to respond. We repeat that right here. Here's all the due processes, again, in a sequence, if you're looking under section 2. And some of those are repeated even here in the judges, because they may have special rules on asking for shortened notice or emergencies. So it's a good idea to do that, and to notice that self-calendaring, we allow parties to pick a date for their hearing, and that can happen only when there's going to be 21 days of notice or more. So that's good to know. And I want to point out something here. Under regular notice, we even provide which motions can be heard on how many days. So here's the general rule, here's the 30 days, and here's the items that require at least 42 days of notice to a party. Now we have special information on emergencies. Believe it or not, sometimes the emergency is caused by you, and that's not really emergency to the court. So we ask you, please do not title your document emergency unless you follow the procedures of this local rule and cite it on the caption page of your motion. Chances are, if you read the rule, and read the central guide, you'll know that it may not be an emergency. You first have to find out if it is an emergency. And because that will involve contacting the judges' chambers, we provide a link to the judges with all the appropriate phone numbers on how to call. We even have a supplement that has the judges' emergency motion contacts, and this comes right out of the central guide. Okay, we have a link, very common now, that all judges post what's called a tentative ruling calendar when there's a hearing coming up. And we have a link for that right here. It's called the tentative rulings calendar, and it goes to here, and then you select your judge on the left side. So let's check Judge Robles right here, and Judge Robles had hearings today. So we'll click on that. And here is the tentative ruling calendar where it lists, it says it's going to be via Zoom. And then it has some information. Parties may appear, blah, blah, blah. And here we go. Here's some additional rulings. So that's right there at your fingertips. There's the only difference between a posted calendar and a tentative ruling calendar. They both look the same, but tentative ruling calendar will be posted close to the hearing to identify things you can find, such as, do you have to appear? And if so, how? Are there any rulings you need to follow? Are there some corrections you need to make? So here's a calendar from a couple of weeks away. There's some hearings that have been vacated, but I'll bet on this calendar, there's some pages that don't have any information at all because the hearing is far enough away. Okay, relief from stay, very common. Let's get rid of some of these forms. Ciao. Relief from the automatic stay, we've touched on that briefly. Let's just do a few more. And here's a feature. So they're all listed under 4001. And because the different types of relief you can file are all under 4001-1C, that's why they just are here. And then we put, these are the little letters that you'll find on the courts forms: CUST, non-bankruptcy, personal property, real property. So here's a popular one, foreclosure. And we have a blurb here on what the automatic stay is and getting relief. And then we link to all the forms you might file. Here's your motion. Here's a boilerplate response that any party can use to respond to a motion regarding the automatic stay. And because this response form can be used for any motion involving the automatic stay, we repeat it under all of these links. Then there might be some declarations that need to be filed, an order granting, here's an order denying, and then this is the optional declaration of default if in fact stipulation is agreed to and there's a default under that. But all the forms are right there at your fingertips in the sequence in which they would be used, not in any alphabetical order or numerical order. It's the sequence they should be used. The same thing is here under personal property. The specific motion, that response we just looked at, particular declaration, order granting, and order denying. And this is repeated for all of these. Let's say it's a motion to continue the stay. Where is that one? Right here. Maybe this is the second or third bankruptcy and the automatic stay either didn't get imposed or it's only on the books or available for 30 days. So here's the motion you would file. Here's the generic response. And then here's an order granting. So the automatic stay, there are a lot of forms attached to each one, and some of them are repetitive, but that's okay. We want them at your fingertips. We don't want to have to send you to one place to look at them. All right, two more things on this are the judge's web pages. So in the judge's web page, we really want you looking at every judge has posted information on how things work in their court. And so we've got the contact information, delivering a judge's copy. What happens if you're providing evidence? Is it in a declaration or live witnesses? On almost every motion, it has to be by written declaration with exhibits that are authenticated in the declaration. Sometimes there's live testimony. The court has to set that up. And if so, the exhibits are presented with exhibit tabs. And then if you have your transcript, we give you some pointers on not just filing or lodge it, but be sure to follow this local rule. And there's all the tabs right there. Now, each judge can have some special tabs on there. Attendance, attending a hearing. If you click on this and go to the web page for each judge, well, let's try Judge Brandt. Here she is. And right here under phone and video appearance, you click on that, and here are the instructions for how to appear in Judge Brandt's court. Is it in person? Or do you have the option of appearing remotely, either by phone or by Zoom Gov? Every judge has that tab on their website, no matter who it is. Here's Judge Johnson out in Riverside, and there it is, phone video appearance. Until recently, this was called telephonic instructions, but because so many judges use the video option, we updated that tab. Now, there are also there's some tabs that are available. We've got, let's go back here. My judge, Judge Zerzolo, he uses a lot of tabs. We did a survey recently and found the four most common hearings were Chapter 11, 13, adversary, and automatic stay. So we've moved all of our forms and instructions applicable to Chapter 11 right here. And then our Chapter 13 forms are here. And over time, many other judges, you'll see these tabs available on their webpage. But we're in the process of doing that right now. And then here's self-calendaring. And over time, this will be called general standards for anything that doesn't apply to these other main topics. The final thing I want to point out about a judge's webpage is something called a judicial variance statement. So every judge has the opportunity to point out if there's any local rules central guide sections or court mandatory forms that they don't comply with? Or even if they do, are there any clarifications? And right now, we have 11 of our judges who've posted a judicial variance statement on their webpage. And let's take the last year's chief judge, Judge Tai, and here are hers. These are her procedures on arguing and proposed orders and various other things. So here is Judge Klein in Los Angeles. So she updated hers just a couple weeks ago on February 4th of 2022. She says she complies with the local rules, central guide, and mandatory, but there's some clarifications and exceptions. This is a great place to find out about your judge. Sometimes these are called local rules. They're not really that, they're just variants from the other things, and they're very helpful. And at some point, we hope all of our judges will have these here. Okay, and finally, on the popular topics, we've mentioned these earlier, appeals. We have a section on appeals that has special rules we have the general rules on filing your notice of appeal and your notice of transcripts and other things and which rules they comply with. And then here's all the forms at your fingertips. In addition, we have pages for the bankruptcy appellate panel right here, the district court and the Ninth Circuit Court of Appeals. So be sure to check through these. We met with staff from each of the district court, the BAP, and the Ninth Circuit to come up with their information and make sure their page was accurate and thorough for all the things that they're looking for. Okay, this is a good time to see if there's any more questions. Jan?
Jeff, we've got just a couple of questions here.
Okay.
Is there a section on Chapter 7 trustees and Chapter 11 trustees?
Section on Chapter 11 trustees, there's certainly, in Chapter 7, there certainly is. We'll do a Control F feature and put in chapter, I can type, Chapter 7 trustees, or trustee. And there we go. There's one, Chapter 7 needs to dismiss a case or pay certain expenses. So if you go, just put in Control F, you'll find the common things involved in a Chapter 7, including asking for permission to operate a business. Let's see if there's anything on 11. And there isn't anything per se on a Chapter 11 trustee, but there are lots of things on Chapter 11, conversion, dismissal, complying with U.S. trustee requirements, various motions that can be filed by individuals. And here we go, disclosure statement and plan. So yes, you can just put that in the Control F and you'll find lots of things about that. Okay, is there another question?
Yes. Do COVID rules on signatures still apply?
Okay, this is a good one. Now during COVID, the court posted a lot of things called general orders right here. And many of these general orders were due to COVID and the public emergency. And one of the rules was on signatures, which, because we require someone to actually take a pen and sign a document for almost every type of filing, except for the attorney or the attorney's assistant, we recognize that it wasn't always possible to get in person with the attorney. And so we authorized documents to be filed with a signature page blank. And then the attorney would put in a declaration that they tried to get a hold of their client. They couldn't meet with them in person, but the client authorized the document to be filed. And then later, when the signature in ink could be obtained, the attorney would obtain that and file the signature page. Well, that exception no longer exists. We're back to holographic signatures for your client, meaning you need to meet with them in person or send it to them in some way that they can sign it and scan it and get back to you. We talked about the exceptions before. If it's a CME-CF signature or the electronic proof of claim process is used, or the ESR. The only item remaining from the COVID is judges' copies. The court decided to limit it. You didn't have to mail one in unless it was 25 pages or more. So that still is in practice. And in addition to that, some judges have decided they don't want judges' copies at all. Go to their web pages under self-calendaring or under their instructions and see if you can find information on whether they still require a judge's copy. Okay, any other questions?
No other questions, Jeff?
Okay, I just want to point out a few things that I would call obscure. They're certainly not obscure in the importance, but they might be obscure in the fact that they're not as often used. And let's run through a few of these. First of all, topics that apply to the district court. So if you want to be an attorney that practices in our district, you have to apply and pay a fee. And that process is right here that's why we link you. We already saw this link for procedure to apply right here. And then the next one is pay your $25 annual fee. And so we link to the page on the district court website where this information is presented and show you how to do. A second specific item to district courts, and attorneys asked us that during our orientation sessions last summer, and that is if you have an order and you get interest, is there a link to interest rates? So we go to our local rule on orders, which is right here, and there it is, orders or judgment interest rates. And here's the authority for that, and we just have a link to post judgment interest rates, and that the district court maintains that information. The next thing is motions to withdraw the reference, and we alluded to that earlier. Our local rule is 5011-1, and it's confusing. We get calls saying, well, where do I file the motion? Now, a reference means that the district court has referred all bankruptcies and all adversary proceedings within a bankruptcy to the bankruptcy court. But some parties may want the entire bankruptcy, or what's more common is an adversary proceeding, or maybe an objection to claim contested matter referred back to the district court, and you have to file a motion. You file the motion with the district court, and that's set forth in the district court local rule, which we link to right here. And then we link to the ways to file documents in district court. So those are three examples of things that are maybe not too common, but are very important, and you want to make sure the procedure is followed. We went through some items already for the United States trustee, which is to their information on bonds and handbooks, and then compensation for a subchapter 5 trustee. It's a little tricky in the code of how a subchapter 5 trustee is supposed to get paid, but they U.S. trustee has put out a handbook right here, a subchapter 5 trustee handbook on subchapter 5 trustees filing their request for payment as an administrative expense, and that it can be on an interim basis or a final basis. Now, another very important thing, which is not obscure in reality, but in practice, many attorneys are not very familiar with 9014 and what is a contested matter. Now, before we doing that, these items are listed down here in 9014. You will notice there is no dash. When our local rules have a dash in them, that means 9013 is a federal rule, and a dash means this is our local rule associated with it. But there are some federal rules that are important that we thought important enough to put them here, even though they're not a local rule. These are not typos. These are actual things. So here we give an overview of what's called a contested matter. Now, traditionally, you file your lawsuit. You have a plaintiff and a defendant. That's an adversary proceeding. But some things are just as important, but you don't need a summons. Those are called contested matters. FRBP 14 explains that here's how you serve it. You might have some discovery rules you can use. And of course, every motion needs notice. And then we provide a list here of items in the FRBP or local rules that are absolutely contested matters. Anything involving the automatic stay, property sale, use of cash collateral, obtaining credit, confirmation of a plan, and objection to claims. And there are others too. So that's what contested matter means. It means it's important. There may be some discovery. There's certainly evidence needed. And most of the time, there will be a hearing set. Those are called contested matters. You just don't need a summons. Now, in doing so, we also want to talk about evidence. So 9014C, how do you prove your claim or approve your request for relief. So we cite the rules that apply from the FRBP and FRCP, and the evidence is supposed to be by written declaration signed under penalty of perjury. If you have exhibits, they have to be authenticated. You can't just staple them to your motion. You have to have somebody who has personal knowledge of their contents and the source. And then once again, sometimes there'll be live testimony from the stand, but it's only if the court arranges it. So bringing your client or your witnesses to a hearing, they're never going on the witness stand without a procedure set up by the judge that gives everybody notice, because then different kind of exhibits can be presented in a different way, including impeachment exhibits. So please pay attention to these. Another one is common mistake with a contested matter is parties file a joinder, but the rules don't allow parties to be joined into a contested matter. You can't just somehow, file a document and now you're a new party asking for relief. So we explain what all that is, and if you want to demonstrate you agree with a motion, you can file a response and call it a response, but please don't call it a joinder. Okay, another thing is evidence. We included the FRBP right here for providing evidence in a trial or contested matter, and we cite the rules, and we even talk about if there's going to be a remote hearing, we've got some video guides that are available on the website. Another thing that's not that common to proceedings, but is extremely important, is a subpoena. Now, a subpoena is again governed not by a particular local rule, but by a national rule. It's 9016. That's why it doesn't have a dash. And what we do is we indicate the purpose of one, the authority to obtain one, the 3 types, that it must be personally served, and how to serve it. And we cite all the rules, along with a warning that the rules are tricky. This does not substitute for you hiring an attorney and studying the rules on your own. But we have all the subpoenas at your fingertips. If you want somebody to appear to give live testimony at an adversary proceeding trial, we have one for that. If there's a deposition scheduled because of a motion or a complaint has been filed, we have a subpoena for that. And then for parties who need to take oral testimony before there's a motion or an adversary filed, there's a subpoena for a Rule 2004 exam. This page is important enough that we repeated it in notice and service, because you think about getting a subpoena and serving it. So here it is right there at the end of section 2. There's also some interesting items about serving something under Rule 4 or Rule 5. So we mentioned that a lot of the places look to see if something has to be served under Rule 45, 4 or 5, and does it have to be served by certified mail or not? And be sure to look for that in here. There's some guidance on that. Because it's not, oh, here we go. Addresses, certified mail or registered mail when it's required. So we went through and looked at all the rules, which parties must be served by certified mail, which may be what documents have to be served if it's certified mail, and what's the right mailing address. So we put together a section on that. Here's another one on a motion to reopen a bankruptcy case. Sometimes the bankruptcy case is closed or even an adversary, and you need to find out, well, do I need to reopen the main case? And if so, do I have to file a fee? And Rule 5010-1 is our local rule on reopening. So right here, we mention that. And then we include the chart right here, which indicates, this is from the old court manual. Do you have to file to reopen the main case? Yes or no, based on what you want to accomplish. And if so, is there a fee? Another thing we also mentioned is filing motions under seal. We already went over that, and that may involve you contacting the court. And so we provided under filing under seal right here, we provided the charts with the phone numbers for the intake divisions and for the court right here. Don't be afraid to call the judge on this one, or the intake. This was especially true during COVID, when we had to meet people out front of the building when they were closed to get their envelopes with the sealed documents inside. And the last one here is a privacy policy. Now, it's the party's duties when you file documents please don't include personal identifiers. That's your duty. The court doesn't look through and find them and alert you, and we don't have optical scanners to read your filed documents to see. But we do have a procedure. If you find a document on the website on Pacer that has personal identifiers like a social security number, full account number, names of minors, full birth dates, etc., you can file a motion to have that blocked from public view, and then the opportunity to refile the document redacted. And it requires, here's the procedure for doing that. We also have procedure if it's a transcript, which we mentioned earlier, what to do if a transcript is going to be published and disseminated, how to get the personal identifiers out there. Because, you know, let's say members of the press can ask for a copy of a transcript. And so it needs to make sure that items are redacted. Okay, a lot of obscure topics. Of course, there's many more, but let's see, Jan, are there any questions about this?
Yes, Jeff, there are a couple of questions here. Some topics are difficult. Can I still call the court for help?
Yes, and this is one you could call the court on right here. What is the form to use? What's the event code to make sure that it's done properly? We mentioned the filing documents under seal. That's one, and we provided the phone numbers at their fingertips. Here's another one where we provide a phone number, and it is the bankruptcy appellate panel. Right here, the bankruptcy appellate panel's phone number is right there. And here's their website, which has their phone number on it, and they welcome your call. And in addition, they have a litigants manual that probably has the number in it as well. Another example, under emergency motions, you're supposed to call the court. So right here, if you want your matter heard on less than 48 hours of notice, you're supposed to call the judge and ask, A, do I need to file my document first, or can you set a hearing without first filing the document? So who do you call to find out that? You call the judge's chambers, and it's right here. And again, if you're not sure, you can call the chambers and ask them, and if they can't tell you, they'll say, sorry, we can't do it. But they may just point you to one of these procedures. And in fact, we provide contacts, especially if you need help filing something, to contact us, live chat support, and the call center. Is there another one?
Yes. Is there an easy place to find the privacy policy on the website if I can't remember the LBR number 9037-1?
Yes. Okay. So again, the privacy policy is way at the end here of the local rules, but a good place to look for it is under forms, because if you're going to file a form, you don't want to fill it in with personal information. So go to forms on this bar right here, click on forms. It goes to our main forms webpage, where it has an overview and then links to all the forms. And look on the right side here, it says privacy requirements for filed documents and how they're supposed to redact it. And here are the things: Social Security, tax ID, names of minor children, dates of birth, financial account. These should never, so these are advice on what part of a Social Security number or other number you can provide, but what you shouldn't. So, and I bet a lot of people are surprised that you can't put in the names of a minor child or the dates of birth. So here they are. All you do is click on forms. You don't click on anything particular. You just hover over the forms tab at the top and click on that. Okay, are there any other questions?
How often will the central guide be updated, Jeff?
Okay, that's a very good question. The central guide, right now, we're working this year to make technical corrections and updates. If a supplement needs to be attached, or as we go through and remove reference to the court manual, the supplements will be updated. So there'll be a lot of updating between now and December 31st. And that's a reason why the court manual still lives here on the court's website. The court manual, but that we do have the chart, and we do want you to use it. Here's a few examples. On every page of the website under resources, it still has court manual, and that needs to be updated. When you look at government mailing addresses, it refers to Appendix D of the court website. So we're going to be spending this year updating it, but we hope that by this December, the technical changes will all have been made, and then it'll be updated twice a year. For example, our local bankruptcy rules get posted once a year. The current version is effective January 3rd, 2022. It's usually in January. And so that would be a time that if there are any versions, any updates in the court manual will be in January. In addition, our forms, we post updates to forms in twice a year, in December or January, and then in June. So that is our goal. 2022, a lot of small updates to make sure everything's accurate. And then 2023 and beyond, twice a year. Any other questions for me?
I think that should do it, Jeff.
Okay, well, I want to thank everybody again for the reminders. Section 1-00 is a great place to figure out a little summary, the public notice chart comparing location in the court manual versus the central guide, and the ways to communicate with the court. And Jan, if there is someone does email the court, how do they get a response?
Well, as soon as they respond to us, or as soon as they send an email to us, we'll be responding within the first, within 48 hours.
Ah, I
Their
see.
email address. Yes.
Okay, very good. And then just one more thing, there are going to be live sessions planned for, I believe it's the first Monday at 2 o'clock, first Monday in April, first Monday in May, and first Monday in June. And then if there still continues to be a lot of people who want to come to a Zoom session, then we'll schedule them after that. Well, that's it for me, Jan. How about wrapping it up?
Yep, well, if there are no other questions, I just want to say thank you again to everybody for your attendance and participation today. And be sure to let your coworkers know about this video and any upcoming live sessions that we have. We'll be posting those on our website and with our communication channels, okay? So thank you again. Thank you, Jeff. Thank you, Mark, and we'll let it go. Have a great one, everybody.